Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, Intellectual Property.
I'm joined, well, first I should introduce myself, I guess. My name's Locke Bell. I'm a partner at Morrison & Forster in our government contracts practice group. I'm joined with Gail Monahan, partner with Dentons, and Fern Lavelli, who is a partner at Jones Day. And as I said, we'll be talking about IP today. And so I'm going to kick us off, and we're going to talk through a number of updates that happened over the last year. But first, I want to talk about some updates that we saw in the area of commercial software licensing, and really in particular enforcement of commercial software licenses against the government when they have violated the terms and conditions or engaged in some copying without authorization of commercial software. And in this past year, as we've seen in a few years recently, there has been a number of cases working their way through the boards and through the courts, specifically with respect to past violations of commercial software licenses by the government. A number of these are related to DoD contracts. A number are related to civilian agencies as well, both of which, as we'll see, license commercial software under the same basic principle, which is that the government, when it's buying or acquiring commercial software, does so just like anyone else for the most case. And like a number of large organizations that acquire commercial software, the government has had its own issues with maintaining compliance and license management when it comes to ensuring compliance with the terms and conditions of those software licenses. And that's led to a lot of unauthorized copying throughout a number of organizations within the DoD. You have some examples here, some cases that we'll talk about today. One, 4DD Holdings, you had over 550,000 unauthorized copies that were made by DHA, the Defense Health Agency, and some others. Bit Management, another example of around 430,000 unauthorized copies that were made by the Navy. And then there's a relatively new case that's been filed by Peraton at the Court of Federal Claims alleging unauthorized use and continued maintenance and support of a little over 2.2 million licenses of software by, I believe, OPM. And so it is happening. And if you're a commercial software vendor, you want to be attuned to what you need to do on the front end to make sure that if you find out the government is violating your software license or making copies without you knowing it or without your authorization, that you are best situated to enforce the terms and protect your intellectual property against the government. So let's start off with a few basics just to set the stage so those of you in the audience who are not immediately familiar with licensing commercial software to the government know the basic ground rules. And it's a pretty simple rule. The government, DoD or civilian agencies, acquires commercial software much the same way that anyone else does, subject to the same customary commercial licensing terms and conditions, except to the extent they are either inconsistent with federal procurement law. The government's not going to be bound by the laws of the state of California or subject to uncapped indemnification obligations and the like, or the license does not otherwise meet the government's needs. Now, there's a little bit of fuzziness there. I think as any of us who have engaged in this conversation with the government before know, who gets to define the government's needs and exactly what that means in each instance can vary and can in many cases exceed what those of us in industry might think is the government's actual needs. So there's some play in the joints there, but that's the basic rule. And otherwise, the government is generally subject to commercial licensing terms when it comes to commercial software. Now, if you are in the unfortunate position of having the government violating your commercial software licensing terms, there are a couple different ways that you can bring that enforcement action against the government. We see those primarily under either the Contract Disputes Act, the same way that you would see any other contract breach claim, or as an action for copyright infringement under 28 U.S.C. 1498, which is in the U.S. Court of Federal Claims. So now let's dive into a little bit of what we're seeing. Now, as you work your way through a dispute with the government over its compliance with your commercial software licensing terms, the first thing you have to do is establish a license. And the government is a little different than most buyers when it comes to establishing a license with the government. As many of you are well aware, you are required to have the authorized action of a warranted contracting officer in order to bind the government, at least as a technical matter. And we've seen that play out when it comes to commercial software sales, especially. One example is this recent decision out of the Court of Federal Claims called Health Estate, LLC. And in that case, the contractor had provided to the government an end-user license, but it was buried into some source code, and they had intentionally, at least as the decision explains it, had intentionally hidden that from any splash screen. They just put it within the source code, never put it in front of a contracting officer, really never put it in front of anyone intentionally, much less a warranted contracting officer. And the court held that was not enough to bind the government. So it's very important, if you are a commercial software vendor, to make sure that you or your primes or your resellers is getting the EULA that you want to enforce in front of the government and getting it either incorporated expressly into your contract or signed by a warranted contracting officer. Now, that's a slight deviation possibly from what we saw in CSOFT a few years ago. Some of you might recall that case where the government was deemed to be put on notice of commercial licensing terms because there was a reference to the license within the contract itself, or at least the fact that there would be a license, and the fact that a contracting officer had never actually put their eyes on the license terms did not mean the government could evade its obligations under that. But I wouldn't rely on that if you're in the shoes of a commercial software vendor. You want to make sure that you're getting these terms reviewed and signed by someone with authority, and Health Estate is a good recent reminder of that. And even if you have a written agreement, there are issues that come up in these cases that we've seen over the years with privity of contract. And many of you are well aware of the concept of privity of contract, but it's new to a lot of folks who sell commercial software to people who aren't the U.S. government, who are very used to enforcing their license terms against folks who have bought through a reseller or distributor. It's not necessarily the case with the government, and AView Technologies Corporation is a good example of that. That was a case that came out of the CBCA in 2022, and there the software vendor had sold its a commercial software through Carahsoft on Carasoft's GSA schedule. The EULA had been incorporated into the contract itself, Carasoft's contract with the government, and the government had violated, at least allegedly violated, the terms of that license agreement. Now, AView Technologies, without the sponsorship of Carasoft, oddly enough, I don't know what the story was there, but by itself, attempted to bring a claim at the CBCA under the Contracts Disputes Act, saying, look, this is my commercial software license, whereby the government was acquiring this commercial software, and therefore it should be treated as at least related to a procurement contract and subject to Contract Disputes Act jurisdiction, and I should be able to bring my claim. And the board said no. We will not be the first board to hold that a subcontractor, someone in the position of a subcontractor selling through a reseller, can bring a claim under the CDA for compliance with a license agreement by mere fact that it was incorporated into what we would otherwise treat as a procurement contract. And so if you're a commercial software vendor and you're looking at these cases, you must turn to yourself and say, well, what can I do to avoid being in that situation? And the best way to avoid being in that situation, if you are not going to be priming with the government, as many commercial software companies do not do, they sell through resellers or distributors, the best thing to do is to make sure that you're baking into your reseller agreements or your prime agreements that there's a commitment to sponsor any claims. And many of you are probably familiar with the sponsorship process, but the idea is that the prime, at least in name, establishes Contract Disputes Act jurisdiction for the boards so that the subcontractor can then pursue their claim in the prime's name. Now, if you don't do that, we were talking about this just before coming out here, and so I'll turn to my co-panelists to get their views on this. But if you read the AView Technologies decision, it almost sounds as if the civilian board is saying to AView Technologies, look, I don't have jurisdiction under the Contract Disputes Act, but this feels like a contract. There's an exchange of binding promises and consideration between the government and the software vendor as the IP owner, and that feels like a contract to me, but it's not a procurement contract. Well, the next logical step is, does the Court of Federal Claims have jurisdiction over this as a Tucker Act contract, notwithstanding it's lacking being a procurement contract? And so I don't know if you have thoughts on the extent to which AView Technologies may have made a misstep by going to the civilian board as opposed to going to the Court of Federal Claims.
I don't know that they did, because if they would have gone to the court initially, I think it's highly likely that the DOJ would have said this pertains to a contract and therefore CDA applies, you have to get a final decision, and they would have probably tried to kick them out of federal court as well, which kind of highlights the problem that you run into in this space, which is finding the right forum, finding the right claims. The government has a lot of kind of built-in self-defenses as a sovereign entity, and that can be tricky just to get your foot in the door in the court. I think they did refile at the court, though, to kind of cover their bases, is my recollection.
And it's particularly galling, right, to contractors, because on the one hand, there's a clear federal statutory preference for commercial items, commercial services, commercial products, commercial services. And so you would think that the government, and a federal policy to respect private IP rights, so you think the government would actually be a lot easier to deal with respect to these types of licenses that they're trying to incentivize contractors to provide, and that the law requires the contractor to provide if it meets the government's needs. It is important, I think, here, it was a civilian agency. I think it would play out a little differently at the Department of Defense, because in the Defense Federal Acquisition Regulation Supplement, there is that clear provision for privity, at least with respect to IP license rights, that would run to the actual owner of the rights, even if they're lower tier or the prime. So there is kind of an interesting falling between regulatory regimes here.
Yeah, absolutely, and that's a very good point with respect to the DFARS. And not to jump the gun and talk about flight safety too soon, but there's a very brief mention of that exact concept in the flight safety decision that I think is sort of overshadowed by all of the rest of the things that came with the flight safety decision. But to my knowledge, it's the first time that the board has actually said, I will hear a subcontractor's claim with respect at least to technical data rights challenges without having sponsorship of the prime. And it dropped a footnote saying, but I probably wouldn't reach that conclusion with software because, as we all know, the Congress has decided not to legislate with regards to software and has decided only to legislate with regards to technical data. So very interesting issues of privity that can play out in these. And I don't know if I had this. Okay, there we go. So the other way, if you don't have a contract, an actual written contract to enforce under the Contract Disputes Act, then your other recourse against the government is by way of copyright infringement. And this is where we've seen a lot of action in recent years. And there are two ways that you can have a copyright infringement claim against the United States. That is, if there's some copying that's done without an express or implied in fact license, then the government has infringed on your copyright. But the other way, the way that we've seen a lot of these cases play out, is even if you have either an express license or an implied in fact license, or the government has an express or implied in fact license, then it can be subject to an infringement action if it has breached what we call a condition precedent to the granting of that license. So some clause that's not just a term or condition of the license, but is a condition precedent such that if the government or if the vendor knew that the government was not going to comply with it, it would have never granted the license in the first place. And that's exactly what we saw in both Bit Management and 4DD Holdings. In Bit Management, you had the Federal Circuit finding that there was an implied in fact license, but that there was a condition precedent to use Flexera license management software in order to restrict the number of users of the software that had been breached. And then in 4DD Holdings, there was an actual express license that had a condition precedent that was violated, and therefore the copying in excess of those licenses was subject to copyright infringement claims and some damages, which we'll talk about here in a second. Now, if you are going to pursue a copyright claim against the government, you have to make sure that you register your copyright accordingly. Now, for those of you not familiar with this process, you do not have to run out and register your copyright today in order to be able to enforce it tomorrow. But if you want to, if you ever end up in the situation where you have to enforce your copyright, you do have to register it with the U.S. Copyright Office, and you can do that retroactively. And if you do it incorrectly, it can get in the way, as it did with Healthy State. Another reason the court denied summary judgment there.
You know, and Locke, that's an important point too, because a lot of contractors, particularly if they depend on Google a lot, probably think of the existence of what they would term a common law copyright, right? That the moment you create the work in an intangible form, you have legal rights. The problem is enforcing those rights. And 1498B is very clear that a common law copyright is not able to be enforced against the government.
And so let's talk a bit about damages, because this is really the area that I'm most interested in seeing how the courts and boards deal with this going forward. In the Bit Management case from the Court of Federal Claims, a decision out of the Federal Circuit a couple years ago, there was an interesting footnote that got into the area of damages that should be assigned to the breach that the court had found. Now, this was a copyright case, but and it involved unauthorized copying of commercial software. And what the Federal Circuit said is that in order to determine the scope of damages here, we're going to look at the Navy's actual usage of the software that exceeded whatever usage it had been licensed to use. And in doing that, because the Navy's breach was the reason that we didn't have full information, we being the court, didn't have full information as to the extent of that actual usage, we're actually going to shift the burden to the government. And the government's going to bear the burden of proving what its actual usage was and the extent to which any of that fell within the license. Now that's, to the lawyers in the room, my ears perk up on that. That's a very important shifting of the burdens for proving damages. And we've seen that play out in the decisions. The Bit Management decision by the Court of Federal Claims and actually coming up with a damages figure talks a lot about this burden shifting. So too does the court in 4DD Holdings. And in that case, they actually came up with a damages figure of just north of $11 million, in part, at least, because of this burden shifting onto the government to actually prove the extent of its usage and whether that fell within the bounds of a license. I think I like that reframing of things, and I'm interested to see how it plays out. It'll be interesting to see the extent to which it plays out in the CSOF decision, which is still pending quantum.
So there's still a practical issue there, right? Which is, even if the burden is shifted to the government, how do they calculate the issue with any kind of confidence that the contractor can rely upon? One common way that that's done commercially, right, is that a customary term in a commercial license for software are audit rights and usage audit rights. Typically, the government doesn't welcome an audit right clause. However, don't necessarily give it up, because what I've seen frequently occur is where the government will say, we're not going to let you come in and access our systems and perform the audit. But what we will do, and sometimes they'll do it on the commercial frequency, which can be annually or every 2 years or something like that. They say, we will run the audit, and here are the metrics we'll use, and we'll true up with you. If you have that opportunity, go for that, because you aren't likely going to access their system. But even if the burden's on them, at least you can have some confidence on how they calculate.
I would just say on the damages front, I think the Ford ED case, they got $11 million. They asked for like $5 billion. So and that decision kind of walks through all the intricacies of trying to prove your damages. And, in this case, they didn't really have a commercial market. They had never really finished the software, I think. And so it was very difficult to probably even get the $11 million. Excuse me.
Absolutely. Speaking from experience, it can be very, very difficult to litigate when you don't have anything but circumstantial evidence about how much copying was going on within the government that may or may not have fallen within the license agreement. So to Fern's point, absolutely, get those audit rights there. One last point before we leave enforcement. There's another way to enforce your IP rights against the United States. It's a path that's been narrowed over the years. It started with this case, Megapulse, and it's actually the only way that you can enjoin the federal government from violating your intellectual property rights. And it comes out of the Administrative Procedures Act and the Trade Secrets Act, but it has, in many cases, been deemed superseded by the Contract Disputes Act. And what I mean by that is, if there is a procurement contract that covers the license rights that the government has, such that your claim against the government really is a breach of contract claim for breach of that license, then this path to an injunction is superseded or foreclosed to you by the Contract Disputes Act. Your only recourse then is in the Court of Federal Claims in a normal breach of contract action, which offers to you primarily monetary damages, but as the Ninth Circuit said in this case, also declaratory relief. Now, in this decision, the Ninth Circuit went further than a lot of other circuits have, and said that the Contract Disputes Act actually precludes all federal actions to enjoin the government from disclosing trade secrets that are related in any way to a procurement contract. It's a great expansion of the Contract Disputes Act vis-a-vis this Megapulse line of cases that we had seen in the past, and would, at least under the Ninth Circuit, foreclose those actions in large part, if not fully. And it'll be interesting to see how that plays out, because it is inconsistent with other courts. But it's important to keep in mind that it can be very difficult to stop the government from infringing your intellectual property, in large part because of sovereign immunity. And the actions that you have to you are either under the Contract Disputes Act or 28 U.S.C. 1498 for infringement. With that, I'm going to hand it over here to...
Okay, thanks. Okay, so Locke alluded to this a little while ago, but there's there's a flight safety case we're going to get into in a few different aspects here. So those are some pretty, I would say, I called them bad, Fern called them challenging rulemaking going on right now with DoD that I think, if you're doing business with DoD, dealing with technical data, software, et cetera, you really want to be mindful of these things and watch them. So a couple years ago, many of you are probably familiar with the Boeing case. Pretty good case for industry in that it held that a contractor could put restrictive markings on technical data that it delivers with an unlimited rights license, as long as the markings don't aim to preclude the government's use of the technical data. That's great. But lo and behold, not long thereafter, the flight safety case comes around. Flight safety basically says that in the context of a commercial technical data where there is no prescribed marking regime that a contractor is required to follow, a contractor that's delivering technical data subject to unrestricted rights license basically can't use what are, I think, pretty customary and kind of normal commercial markings on their data, right? So it kind of it turns the Boeing case on its head a little bit, I think, in terms of just how to reconcile the two. If you're a contractor and you're delivering commercial technical data subject to an unrestricted rights license because it's OMID or form, fit, and function, et cetera, I think this case is kind of baffling as to how you're supposed to mark that data. I suppose you could just not mark it at all, but that seems that Fern and I were talking about this before. It's kind of inconsistent with the whole rubric that's set up.
No, and Gail, that's exactly right. And in fact, one of the many problems with this decision is the bullet point that you make about they even suggest no copyright notice. This is the Armed Services Board of Contract Appeals. As you know, in the DFARS, one of the authorized marking on any technical data or software submission is the copyright notice under the U.S. Code. Now, it's true, under the Burns Convention, you don't have to have a copyright notice and your copyright isn't affected either way. But where this is pure commercial data that we're talking about, you want the notice going to the world, and so you want that market. So to me, this makes no sense at all.
And I guess to make matters worse, there is a pending DFARS rule update out there right now that a lot of people, industry groups have been up in arms about for quite a while because it was sort of snuck into a SBIR rule update, but they're proposing a new unlimited rights standard legend. So right now you would just normally deliver technical data subject to unlimited rights with nothing on it, or you could do something like what Boeing was doing. There's going to be they expressly say in the proposed clause that you're not allowed to do anything other than put this new standardized unlimited rights marking on technical data. This is still it's been working its way through the wickets for a number of years now, but this would kind of change things pretty significantly in terms of marking for unlimited rights technical data. So on that front, in this same rule, there's some other things coming out of it as well. One of the things that I think is particularly troubling is that it's going to shift the burden, it's intending to shift the burden onto a commercial contractor to affirmatively treat technical data pertaining to any portion of a commercial item that was developed with government funding as though it's subject to the non-commercial rules, right? So it's going to, right now, the DFARS is set up to kind of require the contracting officer and the contractor to deal with that on the front end, so the parties can kind of know, up front what what's going to be delivered, what's going to be delivered with which type of marking, et cetera. This new adjustment to the clause for the commercial item technical data is basically going to put the onus, I think, on the contractor, because it'll ideally still would be dealt with up front, but it's going to create instances now where there's going to be fights after the fact, absolutely, because the onus is going to be on the contractor to correctly portion mark out things that are portion mark out pieces of its commercial product and the technical data that relates to it as either subject to the commercial or the non-commercial marking. I think it's going to be really complicated and messy, especially for smaller contractors to manage this. And then I guess on the assault, I guess, the regulatory assault on technical data, there's another proposed case out there right now that would give the government purpose rights license in interface data. This kind of goes along with the modular open systems architecture policy that's been in place for a number of years. But basically what they're going to do is they're going to redefine form, fit, and function and other aspects of the technical data rules to be more expansive, right, and to give the government broader rights in form, fit, and function data, as well as a subset of that, which I would say is this interface data as well. So again, kind of the government just wanting more and more rights in contractor technical data. And then the last one here, quickly, this is just going to expand the time that the government can exercise its deferred ordering rights from 3 years to 6 years. So again, probably not a positive thing for contractors here either.
I would urge any of you who are interested in this and have not done so already to go to the Federal Register and read that DFARS case 2021 D005 implementing MOSA, or Modular Open System Approach. There are some pretty drastic changes, and we all knew this was coming, I think, as Congress sort of directed DOD to take steps in modifying the regulations to enact MOSA. But MOSA is more than just gobbling up a lot of data rights. MOSA is a design approach that emphasizes modularity and plug and play, but you don't necessarily need unlimited rights or government purpose rights and everything related to all of the individual components. in order to achieve MOSA. Yet that's what we're seeing in this regulation, at least in this draft regulation that's there. And it defines a lot of new terms. It defines terms like interface implementation data, and it defines it in terms of not only technical data and products, but commercial software. And it defines it in ways that would extend to source code, and it extends not only, or sorry, did I say commercial software? I meant computer software. It extends not only to non-commercial computer software, but to commercial computer software. And so what DoD is writing into the regulations now is an ability not only to get the form, fit, and function data or the OMIT data related to commercial items in commercial software, but actually to have government purpose rights in any interface data, which would go down to your source code. And that's going to be a very tough pill for commercial software vendors to swallow. And so even if you are not yourself a commercial software vendor, if you are a big prime and you're thinking about how you'd have to message that to your vendors, I think it would behoove you to go look at what DoD is doing here and issue your comments.
And you know, Locke, for me anyway, there's a lot to cheer about MOSA, right, and the open system. For one thing, kind of central and articulated clearly by DoD in this is the concept of segregation at the lowest level possible to protect IP rights. So there's a lot good there, and the concept of a black box where I don't have to show you all the details. But in a way, this good idea and implementing the good idea, it kind of feels like they're parking by sound. And so it's going to be a while before we get there, right?
Parking by Braille, I've heard.
Okay, so back to this is a rule that actually already went into effect January of last year. They updated the validation clause to soften the grounds of which the government can challenge contractors' restrictive markings on technical data pertaining to commercial products and services. Now it's only reasonable grounds to believe, whereas it used to be demonstrates that the item, they had information demonstrating that the item component of the process was not developed exclusively at private. So basically making it easier. I find this interesting because in the flight safety case, which is a lot of bad things came out of that case, the board basically disregarded this language entirely and said that the government didn't have to do any of these things in order to challenge the contractor's restrictive markings. I think this was a troubling outcome, especially for commercial contractors. You know, that you go into it with the idea that you're going to have some protection and you're going to be able to resist the government, challenging your markings. The flight safety case basically blew by all of that. My view is that I think the board didn't appreciate that the validation clause applies to both commercial and non-commercial contracts. It's the same clause. So it has built into it a specific paragraph dealing with commercial technical data for purposes of kind of acting as a gate, right? You have to get past this gate in order to get to the rest of it. The board seemed fixated on the rest of the clause, basically saying, well, how can we interpret the rest of this clause if we agree with flight safety that the government has to get through this first hurdle? And so, I think it led to a pretty unfortunate outcome. Fortunately, this case is up on appeal at the federal circuit, so there's opportunity hopefully to get it right. But this is one of a number of unfortunate things that come out of this case.
Yeah, I think another interesting thing in that case is exactly what you mentioned with respect to the burden, and the board almost blows right past it. But it holds that in cases where the dispute is about whether or not technical data comprise OMIT data, so data necessary for operations, maintenance, installation, and training, but not detailed manufacturing and process data, if there's a question about whether data in their nature are OMIT data, then now, according to the Board of Flight Safety, the contractor has the burden of proving that data are not OMIT data. Now, we all understand that the contractor's got the burden of proving that it developed something at private expense, and that makes sense, and it's built into the regulation and the assertions, or the challenges clause that Gail was mentioning. But it's not so clear to me, at least, that same burden should apply when the government is saying, actually, I think that detailed information is OMIT data. And to shift that burden onto the contractor, envisioning how I would make that argument is very difficult.
Then just quickly, that the time that the government is permitted to challenge a contractor's restricted marks is increasing from 3 to 6 years as well under this proposed case. Hasn't happened yet, but that's where they're moving to. And then the last kind of thing about flight safety, another unfortunate outcome. This one is probably confounding to commercial item contractors. Basically, what the board has held is that any data that you deliver to the government with an unrestricted rights license, so OMIT data, form and function data, other types of data under the -7015 clause, the government can basically do whatever it wants with it. They basically said there's no distinction between an unlimited rights license in the non-commercial context and an unrestricted rights license in the commercial context. So that would include that the government, if it receives OMIT data, form and function, they can use it to remanufacture, reprocure parts from somebody else. Right, and so I think that's a pretty unfortunate outcome if you're a commercial contractor. It also says you've got to be really careful. Again, be proactive on the front end during negotiations. Really control what you're going to deliver to the government. Try to resist giving more than you absolutely have to, because again, the flight safety case is saying that they're going to have pretty much unfettered discretion to do what they want with that, and it can be really detrimental to your business if you've made a big investment in that technical data on the front end. And then the Lockheed case here, just real quick, I'll hit on. This is a software case. The Navy made some strained arguments in this case about what Lockheed had to prove in order to show that it developed the software. They were basically trying to pull in patent concepts about reduction to practice and cooperation and things like that. Fortunately, the board said, no, that's not applicable here, and I think that was a good outcome for contractors and industry.
It also has the virtue of actually tracking the DFARS definition of development, but small victories. So we're going to switch now from technical data and software to rights and patents. And as you know, typically the rights and patents clause is only included in contracts that have a research and development portion. But then the Bayh-Dole Act requires the patent rights clause. Similarly, if you have non-procurement instruments like cooperative agreements and grants, you're not under the Federal Acquisition Regulation or agency-specific supplements, but you're under the grant and agreement regulations. 37 CFR has a patent rights clause. It tracks the Bayh-Dole in terms of concepts and obligations. So the Bayh-Dole Act was originally enacted in 1980, for the first time, so in over 40 years, coming on 45 years, I guess, on December 8th, 2023, just as the holidays were picking up, the National Institutes for Standards and Technology released a draft framework for federal executive agencies to consider when making a decision on whether or not to march in on the patent rights in a federally funded invention. Now, the Bayh-Dole Act actually contains four, what the draft framework refers to as criteria, for the exercise of march-in rights. The first is if the agency that funded the research believes that there's been a failure to take effective steps to achieve practical application of the innovation, they could exercise march-in. Necessary to alleviate health or safety needs, one that we all get, and recently with COVID, understand acutely the need for the government to be acting in that way. Necessary to meet requirements for public use specified by federal regulations, kind of an interesting one. And then the last one, which is if it's necessary because the agreement that the contractor is required to enter to substantially manufacture in the U.S. any subject invention if it's been exclusively licensed to another party, substantially manufactured in the United States. This is the preference for U.S. industry clause. The Department of Energy calls it the preference for a U.S. competitiveness clause, essentially the similar concept. Now, all of you have probably heard, if you've been around government contracting for about a minute and a half, that march-in rights have never been exercised. Now, those of you who've practiced for a while know it's a little more nuanced than that, but that's generally okay, and our merger and acquisition colleagues can kind of take that as their takeaway. So this represents a really significant change and calls into question whether you want to be so glib as to advise that, oh, don't worry about march-in rights, they've never been exercised. Because now we have NIST telling the federal executive agencies that, you should really seriously think about this, and here are some factors to do it. Now, in fairness to the framework, it sets out several objectives, four actually, to provide clear guidance to an agency on the prerequisites for exercising marching rights, and the facts that ought to be gathered and considered as to whether to exercise marching rights. Also to ensure decisions to exercise marching rights support the policy and objectives of the Bayh-Dole Act. To encourage consistent and predictable application of marching rights. That kind of makes sense, although since no agency has ever exercised them, we kind of are consistent at the moment. And then to balance incentives for industry to invest in the development and commercialization of subject inventions and the need to promote public utilization of those inventions. Now, what's interesting to me is that when they talk about consistency and things to consider, as we mentioned on the last slide, there are four criteria that are set forward in the Bayh-Dole Act. Not one of them mentions price. You see the word price up there? Now, when you look, there are actually 7 policies that have been around since 1980-81 behind the Bayh-Dole Act, and not a one of them mentions price. There is one consideration about the cost, but it's the cost to the government to implement the regulations and policies for Bayh-Dole. So nothing to do with price. So this is a pretty significant departure. Now, again, if you've been around for 20 minutes in government contracting, and particularly if you've done work with the National Institutes for Health, with the Health and Human Services Department, you'll know that the idea of using price as a basis to march in is not novel. In fact, for about 2 decades now, there have been petitions, some by Congress, most by public entities or private entities in the private sector, asking NIH to march in particular. And I'm focusing on NIH because in the framework, there's a definite focus on drugs and pharma, although the rule, don't let it fool you, would apply to any kind of subject invention potentially. In terms of the 2 decades of trying to get price as a consideration, we go back to 2004 with Norvir, where members of Congress in a public interest request asked NIH to march in because of the high price of Norvir, which is a drug used for HIV and AIDS treatment. The same year, Exalpan received a similar march-in rights petition, in this case because of the price of the glaucoma treatment being higher than the same exact drug in Canada or in Europe. 2013, Norvir again, another petition, again based on the high price of the medication. In 2016, Zanti, because the price for this prostate cancer drug treatment was higher than in other high-income nations. And then we saw Zanti again just last year, where the petition to march in was based on the lower price that existed in other markets. So it's not a novel concept. What's intriguing to me is that consistently in every instance, including those, NIH has declined to march in based on price. So it's almost a rule that is looking for a sponsor. Although technically it was an interagency group that did it. Now, what's also interesting to me is the stated reason that NIH has been reluctant to march in based on price, which basically sums up in that, one, they don't want to interfere with the market operation, as well as the fair returns, because as you know, in many cases, particularly in pharma, but this again could be true in all kinds of other inventions, there can be millions, tens of millions, and in some cases billions of dollars of investment prior to a successful fielding of a subject invention. The other thing that NIH has been careful to point out is that it's really the realm of the legislature. If they need price to be a consideration or a basis to march in, then maybe the legislature should take action in that event. About the framework, though, what it does is it sets up a number of questions that agencies can use in considering. It keys the questions to the 4 statutory criteria, which is also interesting because the basis for the march-ins that NIH saw was based on the first criterion, which is the practical application. And the argument was that the idea of practical application is to manufacture or to use, to implement this subject invention, but to do so in a manner that is accessible to the public so the public can receive the benefits. And the argument was that price is an aspect of that. So again, not a novel concept. The questions for the agencies are keyed and include a number of other factors like you would expect, things like, is it a subject invention in the first place? Is it in fact being utilized? Is it being made accessible? What are the impacts if we march in? What are the consequences, not only to the particular contractor, but to industry as a whole? So there are a lot of common sense considerations, but on a number of the factors, price, again, is singled out as a legit one. Now, the framework does end by saying that it only is intended, even if it's enacted, to be guidance to agencies. And in that regard, agencies are not required to ask those specific questions, to hew closely to that. They can have other questions, they can have other considerations, and essentially, as you would expect, sister agencies are free to act within their domain and within their reasoned decision-making. And that really is the issue there. This is one to watch. The comment period closed on February 6th, so just last week. There were a number of very cogent comments included that I commend to you. The National Association of Manufacturers pointed out that they anticipate a massively disproportionate impact on small and medium-sized innovators, as well as a chilling effect on private equity investments, venture capital investments, because now the issue of marching really becomes an interesting risk factor. And that really wraps up the presentation. There are other international, it's a confluence, a perfect storm. There are things going on the world stage at the WTO, for instance, with respect to wanting to kind of cause compulsory or even free licensing on a number of very necessary medications. This arises due to COVID, was the specific case that they're using. But so if you're a contractor with federally funded innovations, stay alert. Thank you.
Everyone. So I don't know if the intent is for us to jump in, but there was one written question that we received and that Fern helpfully responded to in writing, but I think it's a topic that we expected to come up anyways, and so probably worth starting off this Q&A session by addressing it. The Federal Circuit has issued an opinion in the AView Technologies appeal and sent it back to the Civilian Board. An interesting decision, sort of a Federal Circuit special in that it leaves open a lot of questions and sort of kicks the can without giving a really clear guidance to the board as to what exactly to do. But the ultimate decision there was, and maybe to sort of set the table, so to remind folks, the Civilian Board in the AView Technologies case had found that MSA or EULA, that was incorporated into a reseller's GSA schedule could not provide the basis for a CDA claim by the software vendor because it was not itself a procurement contract, even though it looked like a contract between the software vendor and the government. The actual procurement contract was between the reseller and the government, and therefore the board did not have jurisdiction. The Federal Circuit said, well, we don't actually need to determine whether or not that MSA or EULA could be itself a procurement contract. That's really a merits question that the board might get to on remand. What's sufficient for us is to say that the claimant, the appellant, AVU Technologies, has at least non-frivolously alleged that if you look at the GSA schedule contract in order together with the MSA into which was incorporated into the GSA schedule in order, that was a contract with the government under which AVU Technologies, by way of incorporation of the MSA, might have a basis for filing a CDA claim. It might be actually a party to the contract or close enough to a party to the contract to have some rights that it can enforce against the government. And so the Federal Circuit sent it back to the board for consideration of all of that on the merits without really any direction as to how to come out on it. But that's the update on AVU Technologies. I don't know, Fern, Gail, if you had more that you wanted to add on that point.
No, Locke, I think that's right. Certainly I have my views on how it ought to come out. It'll be interesting to see how the board takes a look. First, acknowledging, as the Federal Circuit indicated, that AVU had asserted or pled a non-frivolous contract nexus. And then I guess the issue, which we'll all be waiting to see, is whether the board then goes and says, well, yeah, we've got that master service agreement. We have a reseller's GSA schedule contract, and we have the task order, and that was a sufficient nexus to the federal procurement contract to allow the board to have the CDA jurisdiction and then to decide that on the merits.
Any other questions out there? Let's see. So we have a question here. How does an agency remove the possibility of a third-party claim with a vendor that supplies the prime? I suppose that is a question that we will have to wait to see what the civilian board does with AVU Technologies and where it lands. I would not be surprised if on the merits, the board reaches essentially the same conclusion. I'm not sure that that's how they'll come out, but I would not be surprised if that's where they get to. Now, I think there are good arguments for a subcontractor or a vendor who's not in direct privity of contract with the government by way of a procurement contract, nevertheless might be able to address its IP concerns vis-a-vis the government through a direct challenge or dispute or proceeding. The data rights clauses are set up to facilitate that with respect to technical data. There's actually statutory authority for that with respect to technical data, and then the regulations also extend that to computer software. Some confusing guidance out of the ASPCA with respect to whether or not the software vendor can actually pursue those claims, but at least under the flight safety decision, a subcontractor can pursue disputes over technical data by way of the provisions in the regulation. So having that general framework extended to commercial software is not necessarily a bad result in my mind. I think it's helpful for most of the parties involved not to have to unnecessarily get a prime involved in an IP dispute where the IP doesn't involve the prime at all.
And Locke, I think it's important here that this isn't just any third party off the street. So it's not really a situation where the government is blindsided or has no idea that it might have a liability. And in fact, the board itself had assumed for the purposes of its now vacated decision that the master service agreement here was in fact binding on the government. And so I think that's what's important here is the context, the circumstance, where the government knows that it's using something here, intellectual property, software, very specifically, that belongs to a third-party vendor that came with a license rights. This would be a different case if the reseller had not asserted those license rights or hadn't passed them through. You know, I'm not sure that this circumstance and where intellectual property like this is involved, that the government ought to be able to avoid a third-party claim.
Yeah, and I would just add that I don't really view this as opening Pandora's box to, you know, subcontractors are always going to have the ability to go after the government directly. And there's certainly a host of decisions and just built-in, you know, contractual and legal mechanisms that preclude that. So there are a few instances, you know, the IP context being one, where, you know, there is more of an ability for a subcontractor to take action against, but I think it's pretty limited. So if I was the government, I wouldn't be too worried that there's gonna be a slew of direct third-party actions coming out of this.
And there's follow-up here, may have already been addressed, but say, what do we suggest? Does the government now have to confront every third-party software provider mentioned in the EULA? And I think the way I would answer that is you don't have to confront someone unless there's a dispute. The dispute would be brought by, at least in this, the way that we're discussing it, would be brought by the vendor. And presumably, if the EULA that you're referring to might, you know, reference other third-party components that are incorporated into the software that's being provided, that in and of itself might not be enough to open up a connection to those third parties to the government. But if the government's signing up to other, you know, third-party terms and conditions that are incorporated into those terms by reference, I think there's a reasonable argument that just like any other licensee, the government might be open to, and this is all assuming that something that hasn't happened yet, which is that the civilian board finds that this is actually an actionable, creates an action for a CDA claim. But if that were to be the case, then, you know, the government would be open to those lawsuits just like any other licensee would be, if it's in violation of the authorizations of its license. I'm not aware of any way that the government could, sorry, here's the question, could the government disavow such third-party claims? I'm not aware of any way in which the government could affirmatively disavow claims from parties that it has, at least if the civilian board finds, that has entered into a contract with, other than, you know, imposing some sort of limitation of liability, I suppose, but there would be no basis for that, I wouldn't think.
I mean, I suppose, and you do see this, you know, with some frequency. I mean, the government could direct that the prime obtain all the license rights that the government needs in order to use it, but generally that would be in non-commercial instances where. Because as you know, the FAR and DFARS both provide that typically the government would take commercial IP software or tech data subject to the customary commercial license, provided it meets federal law and meets the government's needs. You know, other options are to require only software that has been developed or by the prime. Don't use third-party intellectual property, I guess, is one way. But I agree with Locke. I don't think there's a silver bullet for the government to avoid exposure where it has in fact used and benefited from the third party's software in this case. Lockdale, Gail, I saw that someone commented on the patent rights, the draft framework, simply pointing out what I think was the salient point, which is the government has in fact looked at price of subject inventions and rejected that as a consideration that could itself trigger Martian rights. And I think that's right. That's another reason that the draft framework is particularly interesting.
Like that's all the time we have today. Fern, Gail, and Locke, thank you so much for joining us. I do see we have a couple of questions in the Q&A box. We will capture those and forward those to the speakers and let them take a look. Thank you everyone for joining us today. Thanks again to our great speakers for joining us for the Q&A portion. And you can come back for our next session at 2 o'clock.
Thank you.